stand.
This is a public directions hearing by the Commission as part of an investigation entitled Operation Mantus. At the outset, I should indicate that the Commission has made an order under Section 176 of the Law Enforcement Conduct Commission Act directing that there be no publication of the name or image of persons who will be referred to today by code names unless and until the Commission varies such orders at some future time. As a result, there will be mention of persons today using those code names. Certain police officers will be referred to as Officer MTS1 through to Officer MTS5, the MTS being short form for Mantus. A young person will be referred to as YPM1, YP for young person, M for Mantus. Those terms will be used throughout today's hearing and will be used in future hearings or examinations unless the Commission determines to vary the order made in some respect. In addition, an order has been made under Section 176 of the Act prohibiting publication of the name of the town where events under investigation are said to have occurred. The scope and purpose of the Commission's examination and hearing is to investigate allegations that excessive force was used by a member or members of the New South Wales Police Force at a location in northern New South Wales on 11 September 2022 during the apprehension and arrest of YPM1, a 14-year-old person, together with other issues arising from the detention of that young person in custody following his arrest. The purpose of today's direction hearing is to receive applications for leave to appear and be represented either generally or for a limited purpose of making submissions on procedural issues, including the use of public and or private examinations as part of the hearing in Operation Mantus, the use of code names for persons with the question of identification of any person to be considered at a later time after hearing interested parties in that respect. I have already noted that code names will be used today, and that will be the position unless the Commission forms the view that that order should be varied. Next, the possible venue or venues for the taking of evidence in examinations and the making of submissions at a later point in the process of Operation Mantus. Next, any other procedural issues which are considered appropriate to be raised at this time. There will be no evidence taken today from any person. It is expected that the hearing and examination of witnesses will take place on dates to be fixed in February and March of 2023. Pursuant to Section 64 of the Law Enforcement Conduct Commission Act, the Commission has appointed Mr. Lester Fernandez of Council to act as counsel assisting the Commission for the purpose of Operation Mantus. And shortly I will call on counsel assisting to address a number of matters. It is now appropriate to move to take applications under Section 66 of the Act for persons to be represented for the purpose of today's direction hearing, which relates to procedural matters, or generally for the purpose of Operation Mantus. I should indicate that the Commission has informed a number of parties who may have an interest in today's direction hearing, or generally for the purpose of Operation Mantus, so that applications for leave may be made. At this point, I will call upon those appearing today to make an application for leave using, where applicable, the code name referred to in the list of names and code names which I trust has been provided to the legal practitioners. So if we could commence, who would like to go first?
Chief Commissioner, my name's Jones and I seek leave to appear for Officer MTS2.
Yes. I grant leave to Mr Jones of Council to appear on behalf of Officer MTS2 for the purpose of Operation Mantus. Yes.
Commissioner, please, as Taylor Solicitor, I seek your authorisation to appear on behalf of Officer MTS3.
Yes, I grant leave to Mr Taylor, Solicitor, to appear on behalf of Officer MTS3 for the purpose of Operation Mantus.
Chief Commissioner, my name is Coffey, C-O-F-F-E-Y. I'm instructed by Mr Condon, C-O-N-D-O-N. I seek your leave, Commissioner, to appear on behalf of the Commissioner of Police for today's directions hearing.
Yes, thank you. I grant leave to Mr Coffey of Council to appear on behalf of the Commissioner of Police for the purpose of today's direction hearing.
Chief Commissioner, my name is Samantha Lee, L-E-E. I'm appearing for KPM1, seeking leave to appear for KPM1.
It's YPM1.
Sorry,
I'm
Y.
sorry.
I don't have my glasses.
No, that's all right. Y for young person
YPM.
M. It's a
Thank
question of trying to devise meaningful codes so that everyone
get it
just
now. Thank you.
didn't have the whole series. All right. Yes, thank you. I grant leave to Ms Lee, Solicitor, to represent YPM1 for the purpose of Operation Mantus. Yes.
Chief Commissioner Hall, HAWL, I seek authorisation to appear for MTS1.
Yes. I grant leave to Mr Hall, Solicitor, to appear on behalf of Officer MTS1 for the purpose of Operation Mantus.
Commissioner, my name's White and I seek leave to appear on behalf of Officer MTS4.
I grant leave to Mr White of Council to appear on behalf of Officer MTS4 for the purpose of Operation Mantus.
Thank you, Chief Commissioner. My name is Nagel. I seek leave to appear today on behalf of the Police Association of New South Wales for the limited purpose at this directions hearing in relation to assisting in relation to issues under Section 63.
Thank you. I grant leave to Mr Nagel of Council to appear on behalf of the Police Association of New South Wales for the purpose of making submissions at today's procedural directions hearing.
Chief Commissioner, my name is Willis. I seek leave to appear for Officer MTS5.
Yes. I grant leave to Mr Willis, Solicitor, to appear on behalf of Officer MTS5 for the purpose of Operation Mantus. Does that now complete the appearances? Thank you. It is appropriate at this stage to request Council assisting to provide a short opening concerning Operation Mantus. This is for the purpose of identifying a number of the issues expected to arise in the hearing and examinations, which will proceed in the early months of 2023. In addition, Council assisting will also refer to a number of factors which may bear upon procedural issues, including the use of public or private examinations as part of the hearing in Operation Mantus. So I now call on Council assisting. Thank you, Mr Fernandez.
Chief Commissioner, Operation Mantus arises out of an incident which occurred in September 2022 in northern New South Wales. The incident involved a young person who sustained injuries during the course of being apprehended by police and after which he was arrested. The young person was treated by ambulance and in hospital for a short period. The incident took place at night. The young person was with other young people. Police were conducting proactive policing activities and they were in plain clothes. Police did not wear body-worn video at the time. As a consequence, if there is any dispute about what took place when police apprehended and then arrested the young person, that dispute will not be assisted by electronic evidence. And one of the issues which it is expected will be examined at this hearing and in examinations is why police were not wearing body-worn video at the time of the incident. After being treated in hospital, the young person was taken to a police station. Police wished to interview him. He contacted a solicitor. His solicitor advised police in writing the young person did not wish to be interviewed. However, police did interview the young person. An adult was present during the interview. The second set of, in the chronology, the second period of time in the chronology, leads to other issues which may be expected to be examined during the course of this hearing, including what procedures were followed or were not followed in the conducting of the interview by police, and the young person's management in custody. I understand the Commission will seek submissions shortly about whether the hearing should be held in public or private, or some combination of which, and I'll shortly turn to the matters that may assist the Commission in its determination. The Commission will also be seeking submissions about the location of the hearing or examinations, or part of the hearing and part of the examinations, as well as other procedural matters as they arise. The Commission has already made a number of pseudonym and suppression orders, and their continuing force will also be the subject of submissions in due course. It is anticipated that evidence will be taken at this hearing in February to March of next year. As indicated, the location and venue of the hearing is still to be determined. I'll now turn then to a procedural issue which arises at the outset, and that is whether the hearing or part of the hearing is to be held in public and private. By way of assistance to the Commission, I'll turn to the objects of the Act, as well as to a specific provision in the Act, Section 63, which assists the Commission in determining whether a public or private hearing or public or private examinations should be conducted. I'll also turn to some of the applicable principles. So I'll start then with Section 3 of the Law Enforcement Conduct Commission Act, and I will ask for that provision to be placed up on the screen. Section 3 sets out the objects of the Act, and there are a number of objects. I'll refer to three in particular. The objects of the Act include the following. Subsection B, to provide for the independent detection, investigation and exposure of serious misconduct and serious maladministration within the New South Wales Police Force and the Crime Commission that may have occurred, be occurring, be about to occur, or that is likely to occur. Subsection D, to prevent officer misconduct and officer maladministration and agency maladministration within the New South Wales Police Force and the Crime Commission by Roman numeral 1, providing for the identification of systemic issues that are likely to be conducive to the occurrence of officer misconduct, officer maladministration and agency maladministration, and Roman numeral 2, assessing the effectiveness and appropriateness of their procedures relating to the legality and propriety of activities of their members and officers, and Roman numeral 3, encouraging collaborative evaluation of opportunities for and implementation of desirable changes in such procedures, and Roman numeral 4, making recommendations with respect to education and training about prevention of officer misconduct, officer maladministration, and agency maladministration. And the third object I'll refer to is in subsection G, which is to foster an atmosphere in which complaints, provision of other information about misconduct, and independent oversight are viewed positively as ways of preventing officer misconduct, officer maladministration, and agency maladministration. In order for the objects of the Act to be achieved, there needs to be a substantial degree of public confidence in the work of the Commission. One way in which this public confidence is achieved is by the work of the Commission, when possible, being done in public. Public confidence is also served when the work of the Commission, when necessary, is done in private. I'll turn very shortly to deal with the specific provisions in section 63 of the Act, but I note that those considerations must be understood in the context of the Act as a whole, giving it attention to the functions of the Commission in the ways by which the Act provides it is to or may undertake its tasks. I'll turn then to section 63 of the Act, and I'll firstly refer to subsections 1 through to 4. Section 63 deals with the holding of public and private examinations. Section 63, subsection 1 states that an examination or part of an examination may, subject to subsection 2, be held in public or in private. Subsection 2 states that an examination or part of an examination may only be held in public if the Commission decides that it is appropriate. There's a note to subsection 2, and the note deals with authorisation by the Chief Commissioner in consultation with the other Commissioner about this particular issue, public and private examinations. Subsection 3 states as follows: despite the Commission deciding to hold an examination or part of an examination in public, the examining Commissioner may decide to hear closing submissions or any other part of a hearing in private. Subsection 4 states that subsection 3 extends to a closing submission by a person appearing before the examining Commissioner or an Australian legal practitioner representing such a person, as well as to a closing submission by an Australian legal practitioner assisting the Commission as counsel. I pause there to note that what is reposed in this Commission is a statutory discretion, and it's a discretion with considerable flexibility. Subsection 5 sets out a non-exhaustive list of factors that the Commission may take into account in determining whether or not to hold an examination or part of an examination in public. And it requires the Commission to consider the following: little a, the benefit of exposing to the public and making it aware of serious misconduct. Little b, the seriousness of the allegations or misconduct being investigated. Little c, any risk of undue prejudice to a person's reputation, including by not holding the examination in public. Little d, whether the public interest in exposing the matter is outweighed by the public interest in preserving the privacy of the persons concerned. And little e, whether holding the examination or part of the examination in public may encourage a person with information relevant to the investigation concerned to appear before the examining Commissioner or to otherwise assist the Commission's investigation. The factors to be considered and the nature of the discretion that is to be exercised has been considered in a number of cases, and I'll take the Commission to two cases in particular. The first is the Independent Commission Against Corruption against Chaffey, CHAFFEY. The citation is round brackets 1993, end round brackets 30, capitals NSWLR 21. This was a judgment of the Chief Justice Gleeson, as His Honour then was, the President of the Court of Appeal, as His Honour then was, President Kirby, and Justice Mahoney, Mahoney. The Chief Justice at page 29 of the report noted that although dealing there with a different commission, the Independent Commission Against Corruption, as follows: the Commission was entitled and indeed obliged to take into account the public interest in deciding whether and to what extent the hearing would be in public. That is the same exercise that this Commission will determine. The Chief Justice referred to that statutory discretion being one reposed in the Commission. At page 30, the Chief Justice went on to say this: considerations of public interest which support an open hearing and which were taken into account by the Commissioner include the need for public confidence in the operations of the Commission and the insistence to the investigative process which might be gained from the giving of wide publicity to the allegations being investigated. It was for the Commission to determine the weight to be given such considerations. The Commissioner also had regard to the private interests involved, including those of the respondents. It is important to note that those interests are not necessarily and in all respects best served by hearing the evidence of a particular witness, in that case, in private. The Chief Justice then went on to refer to the importance of public confidence by reference to what had taken place in the United Kingdom and a report in relation to commissions on tribunals of inquiry in 1966. The Chief Justice referred to the following from that report: it is of the greatest importance that hearings before a tribunal of inquiry should be held in public. It is only when the public is present that the public will have complete confidence that everything possible has been done for the purpose of arriving at the truth. Justice Mahoney, in a separate judgment, referred to the principles by reference to the formation of the Independent Commission Against Corruption. His Honour referred to a serious evil that Parliament had determined existed, which was corrupt conduct in the public life of New South Wales, and the particular remedy, which was the granting to an independent executive body a wide power to investigate and make reports in respect of that conduct suggested as corrupt. Once again, making due allowance for the different purposes of the Independent Commission Against Corruption and this Commission, His Honour made the following statement: the remedy which the Parliament has chosen involves, inter alia, 4 things. The Parliament authorised a public investigation of conduct impugned as corrupt conduct. It recognised that public investigation could cause harm to those investigated. As a means of balancing the good of public investigation against the good of private rights, it provided a discretion to hold the investigation wholly or in part in private, and it gave that discretion to an administrative body, the Independent Commission Against Corruption. In this case, the Commission did what the Parliament required of it. It weighed the good of public investigation against the good of the private right not to be damaged by it. His Honour then went on to say, in particular, the following. The scrutiny of impugned conduct in public has a disinfectant effect. The reference has often been made to, quote, the disinfectant effect of sunlight, end quote. And scrutiny in public, rather than behind closed doors, is a traditional check upon abuse of both administrative and judicial power. Further statements of principle were made in the decision of the Court of Appeal in the Independent Commission Against Corruption against Cuneen, Cuneen. The citation is square brackets 2014 and square brackets capitals NSWCA 421, which was a judgment of the Chief Justice Bathurst, as His Honour then was, Justice Baston and Justice Ward. And Justice Baston referred in addressing principles relating to hearings in public and private to the applicable provision in the Independent Commission Against Corruption Act, that being Section 31. The same considerations or factors to be determined or considered are present, with one addition, in the Law Enforcement Conduct Commission Act. Justice Baston referred to the following matters being required to be taken into account. These matters reflect what's contained in Section 63. And the matters were as follows. Subsection A, the benefit of exposing to the public and making it aware of corrupt conduct. Subsection B, the seriousness of the allegation or complaint being investigated. Subsection C, any risk of undue prejudice to a person's reputation, including prejudice that might arise from not holding an inquiry. And subsection D, whether the public interest in exposing the matter is outweighed by the public interest in preserving the privacy of the persons concerned. In paragraphs 100 to 106, His Honour made a number of references to the factors and how they operated. At paragraph 100, Justice Baston, referring to the benefit of exposing to the public and making it aware of corrupt conduct, referred to this first mandatory consideration as being one which, quote, must be read within the broad ambit of the ICAC Act. Thus, the objects of the Act include exposing and educating public authorities, public officials and members of the public about corruption and its detrimental effects on public administration and the community. His Honour went on to say, at one level, those factors will usually militate in favour of a public inquiry. On the other hand, the Commission has the power to report in relation to any matter that has been the subject of an investigation and shall furnish such reports as are required. His Honour referred to consideration being given as to whether conduct in a public whether to conduct a public inquiry where there were potential adverse effects on individuals whose conduct was under investigation. Justice Baston, in referring to the second of the applicable considerations, that is the seriousness of the allegation or complaint being investigated, referred to this consideration having a number of facets. An allegation is to be treated seriously because of its source, because of its subject matter, or because of the potential consequences of the conduct complained, in some circumstances the seriousness of the allegation. All of those matters may militate in favour of a public inquiry. Sometimes they may not. Where the allegations of serious misconduct are of a highly contestable kind, that factor may militate against the taking of that step, that is, holding a public inquiry. Referring to the risk of undue prejudice to a person's reputation, Justice Baston referred to that factor as usually arising from the holding of inquiry rather than the not holding of one, although the latter possibility was recognised. How that consideration will operate, namely the risk of undue prejudice, in a particular case is obviously a matter for discretionary judgment. And that final consideration referred to in relation to whether the public interest in exposing the matter is outweighed by the public interest in preserving the privacy of the persons concerned will require the need to weigh one public interest against another public interest. His Honour went on to say at paragraph 106, the proper balancing of the factors, both known and unknown, was a matter for the Commission. Turning then to the application of those objects and those applicable principles, I come then to the scope and purpose of this examination, which is to investigate allegations that excessive force was used by any members of New South Wales Police during the apprehension and arrest of a young person. That is obviously very serious conduct, and it is conduct which the public would be rightly concerned with. Chief Commissioner, that completes the opening comments which I present by way of assistance to the Commission in terms of the overview of this investigation and some principles applicable to the holding of a public or private hearing, which of course can be in part in public and in part in private. I put up some overheads which refer to the particular legislation, and I tender that document.
Yes. Is it sufficient to identify it as Exhibit MTS1?
Thank you.
Using MTS as short for Mantus again, and
Yes.
the mode used in this commission. The extracts from the Law Enforcement Conduct Commission Act displayed during the short opening of counsel assisting will be admitted and marked Exhibit MTS1.
Chief Commissioner, I think there'll be an overlap with my code name there.
Is there?
That's Officer MTS1. There shouldn't be any confusion about the two.
I should have if you have a copy of the Section 176 order, which I made, I hope all lawyers have a copy.
Yes, Chief Commissioner.
And if you look at the second page, the term officer is used. So I hope that minimises the risk of confusion.
Thank you, Chief Commissioner.
The thinking was the use of the officer clearly indicates it's a police officer, whereas for non-police officers, different terminology has been used at up to this point, YPM1 being the young person. So I certainly want to minimise the risk of any confusion. And any further items that become exhibits today will just be marked serially with the number after MTS1. We won't use MFIs, of course. There's no use in that. This is not a trial or a court where any distinction is appropriately drawn between exhibits and MFIs. So it'll be exhibit MTS 2 and 3, etc., if there are further exhibits. But thank you for raising that with me to emphasise the need for care in the terminology used during today. Well, counsel assisting has delivered a short opening and touched upon some issues that address the question of public and private hearing. I'm conscious that those who are here today appearing for particular interests have had only some general notice as to what was to be addressed today. I will invite submissions to be made on these matters. Perhaps I should note at the outset that Counsel for the Commissioner of Police, Mr. Coffey, has prepared a written submission. As to the order in which people speak, I don't know if there's been any consideration at the bar table of that, but as you have a document, Mr. Coffey, do you want to go first?
Certainly, I can assist in going first if that's...
I mention that essentially because you've provided what is a helpful written submission. The others who have been granted leave to appear have copies of Mr. Coffey's submissions?
No, not yet, Your Honour.
Could I, we've taken the liberty of making half a dozen copies.
Oh, I have some.
I take it you don't have a problem with others having a copy of your submission, and I think it would be very helpful to everyone. Some of your submissions have touched upon similar topics to council assisting,
yes.
But so what I will do is note that the outline of submissions by the Commissioner of Police in respect of the proposed examinations dated 14 December 2022 will be admitted and marked Exhibit MTS2. And I note that copies of Exhibit MTS2 are being made available to those with leave to appear who don't have a copy of it at present. Could I just check whether everyone has a copy now?
Spares if that assists.
All right. Now, as I made clear at the outset, there are orders in place with respect to names of persons and the location, and those orders will remain in place unless and until the Commission is satisfied they should be varied in some respect. So insofar as some of the matters in your written submission touched on that, you can take as a starting point that that's the approach of the Commission. But having said that, I'd invite you to address on this question. Thank you, Mr. Coffey.
Thank you, Your Honour. Thank you, Chief Commissioner. I'm grateful. My written submissions are somewhat lengthy, but I don't propose in these circumstances, particularly in view of the learned counsel assisting's submissions, to go through all of them.
Perhaps I should note one thing. In paragraph 3 of the written submissions, there is understandably a reference to the scope and purpose which identifies the name of the young person and the location. So if anyone, apart from those appearing as legal representatives for interested persons, wanted to look at these submissions, that will need to be struck out. And if there is any other reference, I think they may be the only ones.
I think that's the only one, Chief Commissioner. If it assists, I can always provide a amended version that redacts that, or if that would assist.
If that could be done, it would be helpful. It could be that someone would like an opportunity to look at the submissions, and I see no reason why they shouldn't be available if persons interested wish to see them.
I'd be grateful to also deal with my OCD, the fact that the sub-paragraph repeats paragraph B and B again, so I'd be grateful to be able to provide you a corrected version of that.
That's fine. Let me say at the outset, I'm grateful for these submissions, conscious that everyone's had limited time in advance of today, and one of my principal wishes today was to obtain some assistance in this general area. I understand that it's not something that can be discussed to reach absolutely concrete outcomes based upon some abstract discussion, because one has to say something or think about the circumstances under consideration as well. But it is sometimes the practice of investigatory commissions to effectively determine before any hearing commences whether it will be in public or in private. But the Commission has taken the view that it would be helpful and in the public interest that this discussion take place in open hearing. It's a public hearing. There are representatives of the media present, and I hope that this discussion will assist both the interested persons but also the broader community to understand some of the issues that need to be considered when a commission has to make a decision about whether something takes place in public or in private. And so that's part of the rationale for today in circumstances where there, as you point out in your submissions, there is no decision of a court, at least, as I understand it, that's looked at the particular section in the Law Enforcement Conduct Commission Act, although there is, as both you and Councillor Assisting point out, the Caneen decision concerning a very similar provision in the Independent Commission Against Corruption Act. So I'll stop talking and let you commence.
Thank you, Chief Commissioner. The starting point for those who are at the bar table and listening is that the Commissioner of Police's position is that the hearing should be held in private. However, as an alternative, if the proceedings, the examination is to be conducted in public, as is the case today, those persons who are called upon to give evidence and be examined, being the officers set out within the Section 176 order, should receive the benefit of pseudonyms. That's not to say that where more senior officers, such as, say, an Assistant Commissioner of Police who may be called to give more strategic evidence or more policy position evidence, they would not require such a pseudonym. Could I briefly address you, Chief Commissioner, in relation to the objects set out on page 2 of paragraph 6 of the written submissions in very short compass? It's contended on behalf of the Commissioner of Police that Section 3, paragraph B is relevant in respect of the direction to serious misconduct, as opposed to what's set out in paragraph F under Section 3, where it is to recognise the primary responsibilities of the New South Wales Police Force and Crime Commission to investigate and prevent officer misconduct and officer maladministration within those agencies, and agency maladministration while providing for oversight of those functions. I will make good the purpose of directing your attention to the difference between serious misconduct and misconduct in a moment. It's also relevant to have regard, Chief Commissioner, to Section 26 of the LEC Act, specifically subparagraph B, Roman numeral 1, or I, that is that the functions of the Commission with respect to misconduct matters include the following. B, in accordance with misconduct matters management guidelines, I, to detect, investigate, open brackets, including by carrying out examinations in appropriate cases, close brackets, to expose conduct that is, open brackets, or could be, close brackets, serious misconduct or serious maladministration. Chief Commissioner, the emphasis being on serious misconduct. In respect of the difference between misconduct and serious misconduct, it must be understood, Chief Commissioner, in respect of the objects of the Act and the functions of the Commission. Although Section 4 of the Act provides general definitions, within Division 2 entitled Key Concepts of Part 2 entitled Key Interpretation and Key Concepts of the Act, there is assistance in respect to what is the meaning of serious misconduct. For the purposes of the LEC Act, Section 10 of the Act provides meaning of, quote, serious misconduct, end quote. I'll only take you, Chief Commissioner, to paragraph 1A, and that is because in my respectful submission, B and C, as I understand it, don't arise. Therefore, in respect of paragraph A, it is, quote, conduct of a police officer, comma, administrative employee or crime commission officer that could result in prosecution of the officer or employee for a serious offence or serious disciplinary action against the officer or employee for a disciplinary infringement, end quote. I direct Your Honour's attention, Chief Commissioner's attention with respect to serious offence again. It's important, having regard to section 10, subsection 2, which is set out on page 4, Chief Commissioner, the definition of serious offence, and that is, quote, serious offence means a serious indictable offence and includes an offence committed elsewhere than in New South Wales that, comma, if committed in New South Wales, comma, would be a serious indictable offence, full stop, end quote. Chief Commissioner, it's also relevant to have regard to section 9 of the LEC Act with respect to misconduct. If I could call it misconduct simpliciter for the purposes of this exchange, that is not, quote, serious misconduct. This is done by section 9 providing the definitions of, quote, police misconduct and also administrative or crime commission officer misconduct. When, Chief Commissioner, you turn to section 9, subsection 4 of the LEC Act, there is a non-exhaustive list of examples of what is called misconduct, and in my words, misconduct simpliciter, and those are set out in paragraphs A through D. It's important, Chief Commissioner, to recognise that in paragraph A of subsection 4, conduct of an officer or employee that constitutes a criminal offence is still considered to be misconduct. The delineation is provided by the definition within section 10.2, being that serious offence to give rise to serious misconduct requires the offence to be a serious indictable offence. That is an offence that carries a term of imprisonment of 5 years or more. Chief Commissioner, set out at paragraph 15 and further is the acknowledgement that this Commission has a wide range of investigative powers set out and provided within Part 6 of the Act. Relevantly, Section 51(1) enables the Commission to exercise its investigative powers in respect of those matters set out in subparagraphs A through E. For the present circumstances, the relevant matter arises in respect of paragraph A, and that is A, quote, if the conduct concerned involves a police officer, administrative employee or crime commission officer, and the Commission has decided that the conduct concerned is, open brackets, or could be, close brackets, serious misconduct, or officer maladministration, that is serious maladministration and should be investigated. It's important to note, for the purposes of paragraph A, Parliament has included a note that requires reflection on section 19, subsection 2 of the Act in making a decision under that paragraph. It is important to recognise that there is a broad ambit within section 51 in the powers available to this Commission, and in doing so I make 4 points. The first is that subsection 2 enables the investigation powers to be exercised for 2 reasons, or on 2 occasions. The first, A, following a complaint being made or referred to this Commission, or alternatively, B, on the Commission's own initiative. The second point to be made is that subsection 3 provides a wide discretion for the Commission to exercise powers. That is, A, even in circumstances that the conduct could be, but is not the subject of a complaint, or B, to investigate the actions of another person or body in relation to the conduct concerned. And I think put differently with respect, that is, could be described as investigating the conduct of a third party who is not a police officer in order to exercise the relevant functions of this Commission. Chief Commissioner, the third point to be made is that subsection 4 expressly removes any limitation on the scope available in subsection 3, where the misconduct matter or conduct is or could be indicative of systemic problems involving the New South Wales Police Force generally, a particular area, and that must be understood as a particular geographical area within New South Wales, or particularly a squad or command within the police force, and the Commission considers that it is in the public interest to do so, that the investigation extend beyond any police or administrative employee to other misconduct matters or conduct that relates. Fourth point to be made, Chief Commissioner, is that subsection 6 provides that for the purposes of subsection 1, conduct that is or could be indicative of both officer misconduct and a series of other matters that are set out is to be treated as officer misconduct. Briefly touching on what also Learned Counsel Assisting dealt with in terms of the examination and this question of private versus public, it is clear that the Commission is provided power to hold an examination pursuant to Section 61, and that the question and jurisdictional point in terms of whether the examination is to be held in public or in private is set out in Section 63 of the Act. In my respectful submission, it is contended that when regard is had to subsection 2, the starting point is that examinations are to be conducted in private. Of course, subsection 1 plainly makes available a discretion that they may be held in public or private, but the important point is that they should be held in private and that there is a relevant test provided about whether or not they should be held in public. At paragraph 30, Chief Commissioner, I set out, in respect to this question of, quote, if the Commission decides that it is appropriate, end quote, to hold an examination or part of an examination in public, as Learned Counsel Assisting directed your attention to, subsection 5 provides some non-exhaustive guidance about the matters that ought to be considered. Learned Counsel
Just before you go there, could I just ask you a couple of things, and we'll come back to that. The Canine decision, to which you refer as well, being the decision of the Court of Appeal in 2014, looked at Section 31 of the Independent Commission Against Corruption Act, and at paragraph 98 of the judgment, Justice Baston's judgment, he set out Section 31. There is some difference, I think, between Section 31 of that Act and Section 63 of this Commission's Act. Subsection 1 of the ICAC Act, for the purposes of an investigation, the Commission may, if it is satisfied that it's in the public interest to do so, conduct a public inquiry. And then it goes on to identify a non-exhaustive list of factors. In the Section 63 of the Law Enforcement Conduct Commission Act, subsection 1, an examination or part of an examination may, subject to subsection 2, be held in public or in private. 2, an examination or part of an examination may only be held in public if the Commission decides that it's appropriate. And you submit that that means that suggests that the Commission has to determine whether it's appropriate before it could move to a public examination.
Yes, Your Honour.
The word appropriate doesn't seem to be a word used in the ICAC Act. It is, on one view of it, a word that's not overly demanding. The Macquarie Dictionary says amongst the meanings of the word appropriate is suitable or fitting for a particular purpose, person, occasion, etc. So it's not, by way of contrast, what appears in the independent, broad-based Anti-Corruption Commission legislation in Victoria, where there's an exceptional circumstances test.
Yes.
And with such a test to be introduced, as I understand it, in the National Anti-Corruption Commission Act, which is now passed through the Federal Parliament. So the word appropriate is there, and it's, I don't know if such a word existed in the Police Integrity Commission Act or in any other act that may be exercising similar powers, and I'm not sure if anything in any extrinsic material explains why the word appropriate was used. But I merely point that out because it is what the statute says is the test. Perhaps the other thing that should be noted is that when the Canine judgment is read, what Justice Baston and to an extent Justice Ward said about the public interest must be read in in the context where Section 31, subsection 1 of the Independent Commission Against Corruption Act actually says that the Commission may conduct a public inquiry if it is satisfied it's in the public interest to do so. So there is a direct public interest test. That's not to say that the public interest is irrelevant for Section 63 of this Act, because it's mentioned at least in subsection 5D and must, one would think, be a foundational concept in legislation of this sort in any event, where the Commission is expected to be operating in the public interest generally. But I just make those points. The word appropriate, I've mentioned a dictionary definition. I don't know if there's any other helpful use of the term that may be found. Probably not.
Chief Commissioner, just responding to a number of things that you've observed, I accept for the purposes of the ICAC Act that subsection 1 is a different starting position.
Yep.
That is not, as I contend for the purposes of this legislation, a starting point that the hearing should be held in private. Clearly, subsection 1 of section 31 is a different position and does not include the words appropriate or any similar terminology. Just directing attention back, Chief Commissioner, to the former repealed Act of the Police Integrity Commission dealt with under section 33.
Right.
Having a review of that now at the bar table, it does not contain, it's not drafted in the same terms as the current section 63 of this Act is done. So it starts with subsection 1, a hearing may be held in public or in private, comma, or partly in public and partly in private, comma, as decided by the Commission. Then it's subsection 3, capital A, it sets out without limiting the factors, it provides A through D, which I would say are similar to what's available now. Obviously, we have E within section 63, but ultimately it does not consider the words appropriate.
No, and second reading speech is probably not likely to say anything.
No, I can confirm that neither second reading speech provides any assistance other than the fact that the
It's
Commission...
a negative search is
Yes.
the more common experience. There is, so in any event, that's the word this Act uses, and it's to be given its ordinary meaning, understood in its statutory context though, and obviously subsection 5 sheds light on what is relevant to the question of appropriate, but it's not a substantial hurdle, as it's sometimes said. For example, an exceptional circumstances test would be. Anyway, I've taken you away. Oh, there's perhaps one other thing I should mention before inviting you to continue. Counsel Assisting referred to the Chaffee decision. It is an important decision in this state, although it's nearly 30 years old, because it dates to a time when the Independent Commission Against Corruption was dealing with complaints against police. That's Chaffee and others were in fact police officers.
Yes.
However, at that time, the test for public or private hearing in the relevant ICAC legislation, I think, involved a simple proposition that if the Commission formed the view it was in the public interest to do so, it could proceed with a public hearing, and therefore the court in the Chaffee case concentrated on the term public interest because there were no factors identified of the type which have been introduced since then in the ICAC Act and in turn in the Law Enforcement Conduct Commission Act.
Yes.
As I understand it, the origin for section 31 of the ICAC Act in its present form was a report in 2005 by Mr McClintock of Senior Counsel, who then was requested to report on aspects of the ICAC Act, and section 31 reflects what he recommended, at least in general terms. And so that may explain where that section came from. As to whether that's of any assistance in looking at this Commission's Act is another question.
Yes.
Anyway, back to you, Mr Coffey.
Chief Commissioner, just on 2 points about that is that it's important to recognise that in the current form of the LEC Act, there is not any assistance in respect of what is the public interest or what matters ought to be considered as in the public interest. And as Your Honour observed in respect of my written submissions at 33 and onwards, I identify the Canine decision.
Yep.
That must be understood with respect, certainly not in terms of noting what I've earlier accepted about the difference between Section 31 and Section 63 of this Act. The appropriateness or the relevance of taking, Chief Commissioner, you to that decision was really about the obiter comments made by His Honour Justice Baston about when weighing up all of the factors, not so much just the different tests in when a public hearing would occur.
Yes, and it is helpful. Justice Baston, in his usual helpful way, has looked at these aspects. And I note, although this part of the judgment is obiter dicta, the Chief Justice Bathurst, who dissented on the jurisdictional issue, observed at paragraph 28 that he agreed with Justice Baston and Justice Ward on the other issues, including the public hearing aspect. So this is strong obiter dicta, of course dealing with a different act, but with some of the concepts in the list of factors bearing a considerable similarity to the Law Enforcement Conduct Commission Act.
Yes.
And the decision of the Court of Appeal, of course, went on appeal to the High Court of Australia, where that court dismissed the appeal of the Independent Commission against Corruption. And on my reading of the High Court's judgment, nothing was said in by the High Court that touches on this because it simply didn't arise.
Yes, that's as I understand it. I won't take you through that decision. Learned Counsel Assisting has taken you through it, and I've emphasised in the extract that in the submissions the points that ought to be made. If I could turn now very briefly to, firstly, the question of serious misconduct.
Yeah.
As you acknowledged, Chief Commissioner, in your opening observations, the parties have had, and I don't say this with any criticism or disrespect, that limited time to understand the entirety of the scope of what this inquiry is likely to consider. So I respectfully contend that on the face of, in respect of the conduct with the young person, it is unambiguous, or the definition of serious misconduct needs some attention in respect of whether or not the alleged conduct of the police officer or police officers could or would result in a prosecution for a serious offence, serious disciplinary action, or some sort of disciplinary infringement. But in making that submission, I must make two concessions to be appropriate. The first is an allegation of excessive force could involve a prosecution for an offence of at least assault occasioning actual bodily harm, contrary to Section 59(1) of the Crimes Act. As Your Honour, Commissioner, will you be familiar, this offence carries a maximum penalty of up to 5 years imprisonment, and that, of course, makes it a serious offence, not only because it is a serious indictable offence, but it also satisfies Section 10, subsection 2, and the relevant definition there. It is understood that the involved young person did suffer an injury to his head, which caused bleeding and required treatment by both as paramedics, and I say in my written submissions possibly more. I acknowledge that it's been indicated this morning that he also received treatment at a hospital. Such an injury could, of course, satisfy actual bodily harm. Secondly, Commissioner, the Chief Commissioner, the Commission plainly has the power to investigate, including the conducting of examinations, so as to determine whether or not the alleged conduct amounts to serious misconduct. For the avoidance of doubt, as I said earlier, Sections 10(1)(b) about a pattern of misconduct that involves either more than one participant or is indicative of systemic issues, in my respectful submission, doesn't appear to arise, and Section 10(1)(c) doesn't appear that there involves corrupt conduct. It is, with respect, open in these circumstances that it's possible that it is not serious misconduct for the Commission to exercise powers and refer the matter back to the Commissioner of Police for investigation. Turning more importantly to this question of private versus public examinations, the legislation, as I've indicated, evinces a clear intention that examinations should be held in private unless it is in the public interest to do so. And as I indicated earlier, there is simply no guidance about what public interest is.
I suppose the strictly accurate statement would be unless the Commission is of the view that it's appropriate to do so, because that's what this Commission's Act says.
Yes, thank
The
you.
ICAC speaks of the public interest, but there must be a close interrelationship between those terms, one would think.
I would think so, yes, Chief Commissioner. With respect, Chief Commissioner, as you observed, these allegations are unproven. There is a strong and clear potential that the allegations at this point in time will cause irreparable damage to the reputation of the police officers involved. It is also, with respect, a substantial intrusion into their privacy and their private lives. This must also be understood as an intrusion into the lives of their families, which include their spouses and their children. If I could ask Your Honour at a later point, but have regard to the final sentence in paragraph 95 of the Canine decision, where, in my submission, Justice Baston makes a critical point, which is, quote, particularly is that so where the potential damage to reputation, open brackets, and intrusions on personal privacy, close bracket, result not from considered assessment and reporting of an investigation, but from public examination, comma, often involving questions put in colourful terms and denials which are disregarded, end quote. In my respectful submission, unpacking that particular observation by His Honour, Your Honour Commissioner would have regard to the considered assessment. That must be understood as an assessment undertaken by the examining Commissioner of this investigation, who will subsequently furnish a report to Parliament, as opposed to public reporting which may be done by the mainstream media or community members who follow on via way of social media. With respect, it's common knowledge that it is plainly demonstrated through history that what is often reported is often, with respect, misunderstood, taken out of context, inflammatory, prejudicial, and overall unfair. By making these submissions, it should not be understood that the Commissioner of Police at any step suggests the media should not be entitled to be involved and report on the fact that an investigation is being conducted or the general subject matter. But until a report is published, in the circumstances of this instant matter, it could not be said that the community at large would be harmed or the integrity of the Commission's processes would be undermined by conducting the examinations in private. With respect, in anticipation of any submission to the contrary, being that hearings should be held in public, this must be rejected as falling foul of the statutory provision being 63 subsection 2 and the starting point that examinations be held in private. A private hearing will not prevent the statutory functions of this Commission being achieved once a report is published. That is, the functions of exposing but also providing education about corruption, serious misconduct and serious maladministration. Chief Commissioner, in the instant matter, the conduct of the public examination, but ultimately the findings of the involved officers, sorry, I withdraw that. Chief Commissioner, if in the instant matter, the conduct of the public examinations and the ultimate findings are such that the involved officers are cleared of the allegations, it is probable, if not certain, that it will be too late and the reputational damage and the privacy intrusions cannot be remedied. To put it another way or colloquially, the horse will have bolted if the hearing is in public and there are no pseudonyms. The reputational damage and or intrusion on privacy to both the officers and their families cannot be remedied. As commented by Justice Baston at paragraph 105 of Canine, the preferable course would be to expose to the public by publishing a report and, if appropriate, a recommendation that the Director of Public Prosecutions takes whatever action is appropriate if that so arises out as a result of this investigation. Could I make some more general observations about policing more generally? With respect, policing is a difficult occupation. Police officers must be held to a high standard in the discharge of their oath of office. Police officers, as is in the case of this instant matter, are required to be involved in policing a broad range of different community groups within our community. A many number of the communities within New South Wales are considered to be vulnerable, which presents additional challenges to policing both at building but also maintaining relationships. It is a very real concern, Chief Commissioner, that if a public examination in this particular matter was to occur, which would, with respect, permit real-time reporting, it has a strong potential to strain or damage the relationship between the local police officers and the community. It is conceded that in this particular matter, as a result of the incident, the relationship may already be suffering or strained, but a public examination has the real risk of irreparably harming relations to a further extent. This particular geographical location, it is important to understand, Chief Commissioner, involves police officers and their families who live in a small regional community. The police officers and their family are neighbours to the community members that they police. It is also very important to understand that these police officers' spouses and children work and attend schools and participate in sporting activities with the very same local community that these police officers must engage and police in the discharge of their duties. Chief Commissioner, it's also with respect I submit that this particular community, like other New South Wales citizens and those across Australia, have suffered greatly in the past 3 years, but more so specifically this community. In addition to the impacts of COVID-19 pandemic with the restrictions and the associated social impacts, which are, with respect, long-lasting, this particular community has been the subject of substantial and harmful flooding. This has also impacted the police officers and their families. The police officers continue to provide services and leadership to their local community, trying to keep things back on track in the community, but also back in their own home. It's important to understand that the police officers involved in this local community and the broader police district, their family homes were also harmed. These more specific personal matters are raised because the instant matter is different, say, to the Commission investigating allegations of serious misconduct involving police officers maybe in a metropolitan region, where in that particular occasion it might be more easy for the Commissioner of Police to direct or transfer on a temporary basis those officers to another location until an investigation is finalised. In this particular occasion, in my respectful submission, that's just simply not an available option in circumstances where the police force has police officers who move from the city to the country to be part of the local community. This particular geographical location, Commissioner, the police officers are embedded in the community. It is plain that relations are already strained. If there has been serious misconduct, that will be established at the end of the Commission's investigation, and the Commissioner of Police and her officers can take appropriate steps to respond to the police officers involved, but also, more importantly, to respond to the community and begin repairing the relationship that's necessary. Until such time as the Commission's investigation is finalised, which with respect will involve oral examinations, along with affording procedural fairness through the provision of submissions, and that's often oral and written submissions or a combination of both, the Commission should weigh in favour of private examinations. Returning to the non-exhaustive list Chief Commissioner set out in section 63(5) of the Act, the present matter does not involve a conduct of behaviour, rather it is a single incident. The relevance of this point is that it is unlikely that a private hearing will prevent or have the effect of discouraging persons to make complaints to the Commission or to the Commissioner of Police about alleged adverse behaviour or conduct of police officers or police employees. In the circumstances, it's my respectful submission on behalf of the Commissioner of Police that you would make a decision to hold these examinations in private. If you just excuse me one moment. In circumstances where, Chief Commissioner, you're called upon to make a decision about what is appropriate, I've overlooked raising with you Section 3 objects of the Act under A, that is to promote the integrity and good repute of the New South Wales Police Force. It goes further. The relevance of that, Chief Commissioner, is that by holding a private examination and ultimately furnishing a report to Parliament, will still assist and allow this Commission to achieve that object, that is to ensure that there is integrity and good repute of the New South Wales Police Force, because there will be a well-balanced and reasoned report that considers all available information, not simply information that might be heard as certain evidence is given in the colourful way that often it is given. In respect of an alternative, of course, this commission is not bound by past practice by how previously constituted examining commissioners. But if it was to be circumstances that the commission was to determine that the examination should be conducted publicly or partly publicly, in my respectful submission, as I alluded to earlier, the Section 176 order in its current form should continue. Could I raise in respect of just anticipating it? I have no submissions in respect of the location of any hearing.
All right. Thank you, Mr. Coffey. Who would like to go next?
Chief Commissioner Hall?
Yes.
In relation to MST1,
Yes, Mr. Hall.
in relation to YPM1, the proceedings are on foot in relation to those matters in another jurisdiction. Any public hearing may affect that, and also that other jurisdiction, my understanding, due to the age, would be in private itself.
The other jurisdiction is the Children's Court.
Yes, yes. Those matters are going simultaneously
Yes.
with these matters, and
Yeah.
my understanding at this stage is that, and I can be corrected by the Commissioner, I do think his submissions, that there's been no pleas, or at this stage the evidence is still being put together.
So proceedings before the Children's Court are still on foot,
Yes.
and although those proceedings would take place in a closed court, one would expect, the existence of parallel criminal proceedings, albeit in the Children's Court, is something which you submit is relevant to the question of whether it's a public or private examination.
And we'd ask for a private
Yes.
examination.
Do you seek to adopt the submissions made by Mr. Coffey on behalf of the Commissioner of Police?
Certainly,
Otherwise?
Commissioner.
Yes, thank you, Mr. Hall. Yes, thank you, Ms. Lee.
Thank you, Chief Commissioner. Chief Commissioner, if I could first seek permission to tender some written sub-submissions at a later date at the convenience of the Commission. I've only been made aware of this directions hearing on the 5th of December, and Redfern Legal Centre has minimal resources compared to some other council before the Commission today.
So you'd like a chance to have some time to put something in writing,
Yes,
having regard to what's been said by both council assisting, but also by Mr. Coffey, Mr. Hall, so far.
Yes, Chief
Yes.
Commissioner.
How long would you be wanting to do that?
Even 2 weeks would be sufficient, Chief Commissioner.
Would it be possible to do it a little earlier? I'm just conscious of the time of year.
Yes.
I understand your some time to absorb and respond to what's been said this morning, and all of this this hearing has been scheduled with relatively short notice. So, but I'd be grateful if it was possible to do something by perhaps the middle of next week, being a week, if more time was needed, I suppose. Part of this is the practical future course, namely if we're looking at hearings in February, March, and we're not going to be fixing any dates today for anything. Having some clarity and a resolution on this issue as soon as reasonably practicable is desirable. At the same time, I want to give you a fair opportunity and to put something in writing. So would it be possible to make it 7 days and see how we go with that?
Yes, thank you, Chief Commissioner.
All right. Was there anything that you did want to say today while we're all here, apart from having an opportunity to
Yes,
put something
thank
in writing?
Yes. I have instructions from my client, YPM1, to seek a public hearing in regards to this incident, Chief Commissioner. My client is a 14-year-old boy, Indigenous. He lives in a rural regional area He is of low socioeconomic background. He's a vulnerable person under the Crimes Procedure Act, Section 306, and is subject to the Young Offenders Act. He's not here today, and as you can see, he is outnumbered today of the people before the court, before the commission, out-counselled, but not out-motivated to seek a public hearing in regards to this incident. Commission, I put towards you that it is serious misconduct in regards to Section 3 of the LEC Act. And I also turn, Chief Commissioner, your mind to Section 10(1)(a) of the Act, which says the words could result in a prosecution. It's not the words will or may, but it is a lower bar or that could result in a prosecution. My friend has suggested it could be looking at, if a misconduct is found, looking at assault occasioning. But I submit to Chief Commissioner that we don't have the evidence before the Commission as yet as to the actual injury that was caused, and we could potentially be looking at reckless grievous bodily harm. At this stage we don't know, and that is a 10-year jail term offence. In terms of Section 63, Chief Commissioner, I turn to the benefit of a public hearing in regards to benefit to the public. Excessive force is something that's on the public agenda right now. I raised the recent incident of Danny Lim, a very public matter that has had a lot of public exposure. I can only say that the public interest in that use of force has been extensive. It has infiltrated the community. Excessive force is a big issue within my practice at the Redfern Legal Centre. I am of the view it is a systemic issue. We're not talking about a force against an adult. We're talking about quite serious, potentially quite serious force against a young 14 Indigenous young man. He was, again, in a regional area late at night. We don't know all the specific details yet in regards to that night, but the videos from that night that have been posted on social media are extremely distressing. The videos show a young 14-year-old boy with blood bleeding from his head, and he appears to be going in and out of consciousness. In terms of risk, Chief Commissioner, to undue prejudice, I submit that the risk of undue prejudice, if it doesn't go to a public hearing, is to my client. There's no body-worn video, none, no body-worn video footage. That does disadvantage the Commission in being aware of what actually went on at the time. Video footage speaks louder than words, and we don't have the benefit of that before the Commission. The risk is that a voice of a 14-year-old boy will not be heard. Again, he is outnumbered by the number of police officers who are represented here at the Commission. His voice needs to be heard in public. Public hearings shed light on police behaviour. As you mentioned, the word appropriate is a much lower bar than in regards to a public hearing under the ICAC Act. I submit, Chief Commissioner, that it's appropriate to air this issue in the public. The public hearing educates the public about police behaviour and potentially deters police from further misconduct. Public hearings provide knowledge also about the LEC's function and provides knowledge about the transparency of the process. It also improves integrity in regards to the LEC, and also informs people about the police force and looks at integrity and transparency and accountability in regards to New South Wales Police. Chief Commissioner, I won't go into all the casework. I can see that it's already been submitted. My submission is that my client wants a public hearing. He doesn't have a voice at the moment in regards to this matter, except what's been shown on social media. He would like to have a voice, and he would like some transparency in regards to not only himself, but the way Indigenous First Nations people are treated, particularly in regional and rural areas. Thank you.
What I'll do before we conclude today is ask if you could have provide any additional written submissions to the solicitor assisting the Commission by 1 p.m. next Wednesday, the 21st of December. If there's some insuperable difficulty with that, if you could indicate that, but you've helpfully outlined the argument that you've put, and to make sure there's a proper opportunity to address anything else in particular by reference to what you've heard and seen today, I would hope that may be sufficient time. So I'll make an order to that effect before we finish today.
Thank you, Chair Commissioner.
Thank you, Ms. Lee. Yes, who'd like to go next?
Thank you, Chief Commissioner. Given that the Police Association received notice yesterday afternoon of the matters that were to be canvassed today, we'd seek that we have until 1 p.m. next Wednesday as well to give you something in writing.
Yes, I was conscious, and I'm sorry that the notice was that late. There's been a range of work done with respect to this matter and some other issues in the Commission in recent times, and I had overlooked, and I apologise for it, the fact that the Police Association would have an interest in this. It's a general topic.
Yes.
It's of importance to the members of the Police Association, and so I wanted to ensure that there was an opportunity for something to be, for participation today, but hopefully with the benefit of what you've heard and the written submissions from, on behalf of the Commissioner of Police, that will assist. So I'll make sure that you have until 1 p.m. next Wednesday, the 21st of December as well.
Yes, thank you. And we appreciate the opportunity to make submissions and to assist you in understanding the scope of the power, given that the LEC Act is 6 years old, but before that there were things like the Tink Review and the previous PIC Act and the differences in the language. So we'll try and give you some of the historical significance of that. And whilst it's not on the second reading speech, the explanatory memorandum does deal with this matter as well. So we'll send that through.
That would be helpful. I should indicate too that as Justice Baston observed in the Canine decision, that it's often helpful to have guidelines generated by the particular commission in this area, but he noted there weren't any which the ICAC had at that time. I can't speak for the ICAC now, but there are no guidelines of the Law Enforcement Conduct Commission in this area, certainly at present. At earlier times, and perhaps in the days of the Police Integrity Commission, there may have been something I frankly cannot recall at this point. But
yes, well, we'd welcome the opportunity to assist with those formulating those guidelines and being heard in relation to them, should that general guidelines be something that the Commission thinks is appropriate.
Well, what we're heading towards when we end today is I'll adjourn and reserve a decision on this topic, where I will in due course give a decision that will be circulated to everyone and I think made public with no identifiers in it. I'm not a judge anymore, so I can't make decisions of the type that was possible in the past, but this is a matter where there would be consultation as well with the Commissioner of this Commission. We bear joint responsibility in the operation of the Commission, and it may be that this decision will, insofar as it speaks generally, fulfil the type of function of guidelines without necessarily calling them guidelines. But we had to start somewhere, and that's what's happening today. And the submissions being made are of assistance and will continue to be of assistance. There'll be a written decision which will be available, and hopefully the end product will be of assistance to everyone who has matters before this commission in the future. But thank you for that, and I'll make sure that there's that opportunity for submissions to be made in that way. Thank you. Yes.
Commissioner Taylor, Solicitor on behalf of Officer MTS3.
Yes, Mr. Taylor.
Firstly, can I thank Mr. Coffey for his detailed written and oral submissions today. Given my lack of knowledge of the particulars the Commission will actually be investigating in the matter, I don't think there's anything I can say which would assist the Commission in coming to a determination in respect to these issues, so I wouldn't seek to file any written submissions or make any submissions today, but I would seek to adopt the conclusions that Mr. Coffey came to in his written submissions in relation to whether the Commission should hold a public or private hearing, and if it is to be a public hearing, then the use of pseudonyms in accordance with the previous practice.
But you don't seek an opportunity to put anything in
I
writing?
don't think there's anything I could provide to you in 7 days which would assist you any further.
All right. Well, thank you. Yes, thank you, Mr. Taylor. Yes. Mr. Willis.
Chief Commissioner, on behalf of Officer MTS5, we adopt the submissions made by Mr. Coffey and support the contentions advocated by him under the heading of conclusions. And there's nothing that I can usefully add to those.
All right, so you don't seek an opportunity to put anything in writing, having heard what you've heard so far today? All right, thank you, Mr. Willis.
Chief Commissioner, on behalf of Officer MTS2,
Yes, Mr. Jones.
I would also gratefully and respectfully adopt the submissions of my learned friend, Mr. Coffey, and I don't seek to provide any written submissions.
Right, thank you, Mr. Jones. Yes. Chief Commissioner, on behalf of Officer MTS4, Chief Commissioner, I also adopt the submissions of Mr. Coffey. If I could just add one matter though, Commissioner, in relation to section 63, subsection 5B, concerning the seriousness of the allegation, I have instructions in relation to this matter. My instructions do not go to the issue of the subject incident. At this point in time, I'm not aware of what the allegations are in relation to excessive force. I'm not aware how many police officers are alleged to be involved, and I'm not sure, or I'm not aware of any of the circumstances relating to the subject incident. So it is difficult for me to make submissions in relation to 5B in relation to seriousness of the allegations. Nothing has been said by counsel assisting today in relation to those particular issues. All I'm aware of is excessive force, which could of course be serious or it could be minor. And I would have thought that issue is relevant to that particular factor. But I'm just not aware of that, so I'm limited in terms of what I can submit about that. But I certainly adopt what Mr. Coffey has said in relation to the section generally. I also raise particularly, based on the instructions of my client, the issue concerning risk of undue prejudice to a person's reputation. I don't think I can add anything to what Mr. Coffey helpfully said to the Commission today about that issue. It is a matter of concern to my client, and particularly because of the geographical location, and I adopt what has been said by Mr. Coffey in terms of the difference or the different issues that would arise, for example, in the Sydney metropolitan area, as opposed to the geographical area where this occurred, where my client has family, has children, who would all be affected by a public hearing. But that's all I wish to say. Thank you, Commissioner.
All right, and you don't seek to put anything in writing, Mr. White?
Well, I'd like to see what's been said by, I would like to reserve my position subject to whatever submissions are made by other parties, but I would expect I wouldn't, Commissioner.
Yes.
Commissioner, if I could just mention, my friend mentioned that the risk to the officers, these issues were raised in the other public hearing, LEC held, which is the strip search public hearing. There were, as far as I know, that those matters have been dealt with, and I can't see how this potential public hearing may be any different to that public hearing. Also, there is a risk to my client who lives in a regional area in terms of the impact on him in terms of his relationship with police, and he is still willing to have a public hearing. Thank you.
Thank you. I should just indicate before turning to counsel assisting, I am aware that there is a report of this commission in Operation Tambora, Tambora, of September 2018. It is not presently on the commission website because there are outstanding criminal proceedings arising from it. But in the context of that operation, the commission took submissions on the question of a public examination or private examination, and the decision of the commission in that respect, which was in fact issued under the hand of the then Chief Commissioner, the Honourable Michael Adams QC, as he then was, the Honourable Lee Drake and Mr Patrick Sadie, is Annexure 1 to the Operation Tambora report. I mention that because, as far as I understand it, this is the only time where the Commission, in the context of that operation and investigation, looked at Section 63. The decision, which is Appendix 1 to that report, summarises submissions made and the conclusions reached by reference to the statutory factors in Section 63. It does not, as I understand it, extend to referring to decisions such as Chaffee or Caneen, but it deals with Section 63 issues. If any party who's been granted leave would like access to that report and doesn't have it, because it's not physically available on the website given the current criminal proceedings, the solicitor assisting the Commission can make that available electronically to anyone who would like it. I mention this for completeness because I'm conscious that the decision made in that matter was made in the context of that matter, but it's the closest that I'm aware of where the Commission has considered Section 63, its operation, and has published a decision. So I just mentioned that, and if anyone would like that, please raise that with counsel and solicitor assisting, and it can be made available, and it may be of assistance to those who wish to put anything in writing. Is there anything you'd like to say at this stage, Mr Fernandez, in light of what's been said?
No, thank you, Chief Commissioner.
The way forward then any written submissions to be made at this stage? Ms Lee and Counsel for the Police Association have identified the position. What do you suggest is the best way of dealing with that, Mr Fernandez? We're closing in on Christmas. Those submissions will come in on the 21st of December. Question arises as to whether those submissions should be circulated to others who have been granted leave for the purpose of today and who have an interest in this. Which may itself raise the possibility of someone wanting to put something else in writing, perhaps including yourself.
Yes.
At the risk of having cascading written submissions, I'm not sure there's any way of minimising that risk. The purpose of today was to allow the Commission to be assisted and fully informed, and if it takes us into the new year, it takes us into the new year. And the reality is that some decision ought to be made known certainly by early February at the latest. Now, that doesn't stand in the way, I suppose, of making some arrangements, but it may be that any arrangements are looking at the latter part of February and into March rather than anything in the early part of February. I just say that as a matter of practical reality of where we're up to. So what would you submit as appropriate if anyone, on the basis that any submissions that come in by 21 December will be electronically circulated to those who have leave today? They have an opportunity to put something in by, what would you suggest?
I'm just mindful that because of the time of year,
well, all of that,
realistically-
and I'm not suggesting it has to be a week later, the 28th of December.
in deference to all concerned and the time of year, we're looking at January.
Yeah.
Chief Commissioner, and I wonder if the 20th of January gives everyone sufficient time.
Yeah. Well, I don't have a difficulty with that. I'm just speaking generally to the bar table on the basis that these further submissions are circulated on 21 December. An opportunity for anything to be put in response by 20 January, is that an invitation that people would want to take up?
Yes, thank you, Commissioner.
Yes.
Now, for you, Mr Fernandez, do you want anything beyond 20 January?
I will ask for perhaps Wednesday, the 25th of January, Your Honour.
And the next step would not involve, as I see it now, a resumed public directions hearing, but rather the having regard to all the submissions that would have passed a decision.
Yes.
In circumstances, of course, where the decision to be made, given its very nature, which is interlocutory, that circumstances may change, and what the decision would be based upon the issues of law which have been advanced and the nature of the investigation, the position as the Commission sees it at that time. And so it's a process which is capable of being revisited if circumstances warrant it.
Yes, that's so.
And that has to be the position. Well, does anyone want to say anything against, and just thinking of it, if I'm prepared to make 21 December, 22 December, which is one extra day, Ms Lee, and bearing in mind 22 December for the submissions on behalf of the Police Association and YPM 1, and 21 January for submissions from anyone else, and 25 January for council assisting. Does anyone want to say anything further about those dates before I formally make an order to that effect? All right. The Commission has received helpful written and oral submissions today on issues of a procedural type which were identified for consideration today, and in particular the use of public or private hearings for examination of witnesses, to allow interested persons who have been granted leave to appear today an opportunity to consider and respond to submissions that have been made so far. I make the following further directions. The Police Association of New South Wales and YPM 1 should furnish any written submissions by email to the Solicitor for the Commission, Mr Ewan, by 1 p.m. on Thursday, 22 December 2022. Those submissions will then be circulated by email to each of the legal representatives who has been granted leave to appear today. Any of the interested persons who have been granted leave to appear today who wish to respond to the submissions made on behalf of the Police Association or YPM 1 should email those submissions to the Solicitor for the Commission by 1 p.m. on 20 January 2023. Those submissions will be circulated by email to the legal representatives who have been granted leave to appear today. Finally, council assisting is to furnish any written response to submissions made by email sent by 1 p.m. on 25 January 2023 to all legal representatives who have been granted leave to appear today. The Commission will give a decision on the procedural issues, essentially the public-private hearing issue, thereafter, and that decision will be furnished to the legal representatives granted leave by email at a date after 25 January 2023. What course do you propose, Mr Fernandez, as to procedural arrangements for next year? Is it best, rather than having a discussion that may not take it very far in public, to leave it to communications between yourself, the solicitor assisting, and the affected parties as to possible available dates? The question of venue and location has not been discussed. In some respects, that perhaps is best not discussed publicly because it does involve a process of identification more specifically of the location in question and the location of persons who may be likely witnesses. And so I think that's probably best not addressed publicly, but there clearly should be an open line of communication with the legal representatives in question now that we've got to the point of leave having been granted and the process is underway, at least for procedural purposes.
Yes.
And the availability of legal representatives will be taken into account in any fixing of dates as part of that process, and I'll leave it to you and the solicitor assisting to speak to them in that respect.
We'll do that very quickly.
Does that then complete everything that was sought to be?
There's nothing further
Achieved
to be
today.
raised, Chief Commissioner.
Well, could I thank everyone who has appeared today at short notice to assist the Commission. The Commission is conscious that the matters under investigation occurred only 3 months ago. It is important that the matter be progressed as it has been so far today. It is also important that examinations take place in the early months of next year, in due course be, without any delay, a report issued by the Commission in due course. It is in the public interest that this process, once the Commission is engaged in an investigation, proceed as soon as reasonably practicable, and the report issue thereafter as soon as reasonably practicable. So this has been the first step today in that process. And I once again thank all legal representatives who have attended today for their assistance. So the Commission will now adjourn.
All stand.